Good afternoon, everyone. Thank you for joining us. I'm Ben Evans, Head of Trademarks here at Harper James.
And I'm Jill Bainbridge, Head of Intellectual Property at Harper James.
Today's webinar is on design rights, a valuable but often overlooked intellectual property right. In fact, I think it's the most overlooked and underused of all intellectual property rights.
So our plan today in the webinar is to explain the designs which can be protected, how you go about securing them, and how to enforce your rights, and what other types of intellectual property you could use to protect your designs.
So to start, let's clarify what we mean when we're talking about a design. In legal terms, a design relates to the appearance of a product. This includes things like shape, configuration, pattern, texture, or ornamentation. And that's whether the product is physical or digital. For example, it could be the distinctive shape of a bottle. So on the slide there's the distinctive Coca-Cola bottle. It could be the pattern on a dress or the styling of a product's packaging. What it's not, importantly, it's not the way that a product works. Potentially that could be a pattern. It's not a design. When we're talking about designs, we're talking about what something looks like. So in the UK, there are two main types of design protection. There's unregistered design rights and registered design rights. Unregistered design rights arise automatically when you create what's known as a qualifying design. So for these purposes, a design means the shape or configuration of the whole or part of an article or product, but it doesn't include its surface decoration. So if we think about that dress example, a UK unregistered design right will protect the shape of the dress, so the outline effectively, features on the dress, so that could be the placement of straps, the placement of buttons, etc. But it wouldn't protect the pattern that might be on the dress. That would be surface decoration, so that's not covered by an unregistered design right. Now, a design qualifies for protection only if it's original, and that means that it can't be commonplace in the design field in question at the time it was created. In addition, there are certain designs or types of designs that don't count as qualifying designs, and so aren't protected as UK unregistered design rights. And they include things like methods or principles of construction, what we call must fit or must match parts. Must match means parts that basically have to look the same to fit other pieces, other articles or other parts, so that something looks right as a whole. And the best example of that is spare parts for cars. So if we think of a body panel of a car, for example, well, a replacement body panel has to be a particular shape so that it matches the rest of the car. And so that element of it wouldn't be protected as a UK unregistered design because it's a must match part. You also get must fit parts. And they are where, for example, if we use the car example, a charging cable and the connector of a charging cable, that has to be a certain shape. It has to work in that particular way so that it can connect to the charging point. So again, that element would be must fit and wouldn't therefore be protected as a UK unregistered design. In addition, the one I've already mentioned, surface decoration, isn't protected under UK unregistered design rights, but it can be protected using other IP rights, which we'll come on to. UK unregistered design rights last for up to 15 years from the date the design was created, or 10 years from the date the product was first marketed. What's really important about UK unregistered design rights are they are not monopoly rights. So if you want to show infringement, so if you think someone else has done something that's too close to you, to your design, then you have to be able to show copying. That UK unregistered design right isn't infringed if a competitor came up with something the same or similar, but they did it independently. So the actual test is to show that there's been copying of the design so as to produce articles exactly or substantially the same as that design. So that's quite a high burden to get over. Now, I should mention, is at the bottom of that slide, there's a second form of unregistered design protection available in the UK. It's called a supplementary unregistered design, also known as a SUD. which doesn't sound quite as nice. So these came in as a result of Brexit. So they replaced, in the UK at least, what used to be an EU unregistered design right. So that right still exists in the EU, but because of Brexit, it no longer covered the UK. So the UK brought in SUDs. So the SUD is a UK only right, and it protects the appearance of a product or part of a product, including its shape, the contours, lines, textures, ornamentation, and importantly, surface decoration. So it's very similar to a UK unregistered design right, because it protects the shape of the dress, if we use that example again, as well as the placement of certain features. But it goes that one step further, and it protects the pattern of the dress, even the texture of the dress. So it's that surface decoration that the SUD gives you. Now, like UK unregistered design rights, SUD protection arises automatically. And so for a SUD, it arises when you first make that design available to the public in the UK. To be protected, it needs to be new and have individual character compared with what's already on the market. And purely functional features, they're not protected under a SUD. So that protection lasts for only 3 years. So it's super short in terms of its duration. And like an UK unregistered design right, it's not a monopoly right. So it protects against copying. And that's copying of whole or part of the design. But it doesn't protect against independent creation. So there's some key downsides with both these types of unregistered design rights. Firstly, if you do get in a dispute, well, you need to be able to show what was created and when it was created, because it's not a registered right. So there isn't a register you can refer to or a certificate that you can wave around. You need to show copying, which I always think sounds straightforward, but actually having evidence of copying is fairly rare and can be quite difficult. Also, UK unregistered design rights don't protect surface decoration. A SUD does, but it's just got that super short 3-year protection, so really not very long. So that brings us on to registered designs. Now, I mentioned at the start that design rights as a whole are probably the most sort of overlooked general type of IP right. I'm going to say that registered design rights are absolutely the most overlooked form of IP protection. They really are largely ignored and forgotten. Now, as the name suggests, in order to obtain a registered design, you need to go through a registration process. I'll come on to exactly how you do that in a couple of slides' time. But first, I just wanted to talk through the basics of actually what is protected, assuming you get a registration. So a UK registered design right can protect the appearance of a product, which would include features such as the lines, contours, shape, color, texture, materials, and ornamentation. But most importantly, it can also protect surface decoration. So if we go back to the dress, it can protect the whole thing, basically. There are things that can't be protected or aren't protected by a registered design, and that includes features of appearance that are dictated solely by the product's technical function. So things that have to be like that to make it work in that way. Must fit parts, which I've already mentioned, and features that aren't visible during normal use. So the inner workings of whatever your product is, they're not going to be protected unless they are usually visible in normal use. And that's because designs are about appearance, are about what you see. They're not about the way that something works. So having some gubbins hidden away inside it is not going to be covered by the registered design. Also, you can't protect a design that's contrary to public order or morality, but that very rarely comes up. In fact, I've never had a practical example of that. So to get your registered design, you need to file an application to the UK Intellectual Property Office, which is in Newport in Wales. You pay a fee, you get the design registered. In a couple of slides, I'm going to go into exactly what you do about that. But what's important is that the design needs to be new, which means it hasn't been previously disclosed, and it needs to have individual character, which the simplest way to look at that is it needs to look different from existing designs on the market. Now, there is a 12-month grace period. And what that means is it gives you 12 months where you can, if you really wanted to, disclose your design to the public. And in doing so, you wouldn't be jeopardizing the eligibility for registration of that design. It's important that that relates to disclosures that you make. So if a third party somehow gets hold of your design and discloses it, so it's not you, it's not under your control, then that would not be covered by the grace period, and potentially that would then damage your likelihood of registration, because that would render the design as probably by that point not new, and also not having individual character. You also need to be aware that relying on the grace period may limit your ability to secure protection elsewhere, so in other countries. That's because the UK has a 12-month grace period, but not every country, one, has a grace period, and two, if they do, they don't always have it at that same duration. So my advice, if you think something is registrable and you think it's worth registering, then file it before you disclose it. Use that grace period as a backup for designs that slip through the net, either because you've maybe just forgotten about it, which happens, or because you've launched something not expecting it to be particularly popular, but actually it's been a real success. And then you go, okay, right, maybe we should secure some protection here. Protection for a registered design is renewable every 5 years, and potentially can be renewed for up to 25 years. So much longer than the maximum of the unregistered rights, which, if you recall from that slide, the UK max for the UK unregistered design right is 15 years. So this will give you much longer protection. A UK registered design right gives you as the owner the exclusive right to use that design and to prevent others from making, selling, importing, exporting, or using products that incorporate that design, or a design which does not produce a different overall impression to that design. We'll come on to what overall impression means shortly. It also then gives you the right to take action against someone that does any of that stuff for infringement of your design. Now, what's important here is, unlike the unregistered design rights, the registered design right is actually a monopoly. So that means you don't need to show copying. You just need to show that someone's product creates the same overall impression as your design. So potentially you could take action against someone that has come up with it completely independently and has never seen your product, provided you got a valid registration. Now, before you invest time and money in developing or registering a new design, it's a really good idea to check what's already protected. No one wants to be on the receiving end of a cease and desist letter, so important to look before you leap that side. At a very basic level, you can run your own Google searches. Other internet search engines are available, I should say, and they can help you spot potential conflicts. If you've already got some drafts of your design or your product ready, or maybe you've ignored me a little bit and you're further down the line and actually it's completely ready, you're just thinking about registering it, then you can use image search on Google. So upload your drawings, upload your design, and let that do some heavy lifting and potentially identify what may already be out there. You can also just check what your competitors are doing, to check their websites, go to the trade show, see what's going on. I should stress, obviously, you can't copy them because they may not have registered rights, but you could yourself fall foul of unregistered design infringement if you end up copying them. So don't copy them, but you want to check what's already out there. So those kind of searches will give you a good idea as to what's currently on the market. It won't show you what designs are registered. You can run your own searches of the UK Design Register via ipo.gov.uk. It's not the most user-friendly functionality because everything's split by type of design. So something like a piece of furniture is in one category, a bottle might be in another. So you have to really kind of drill down, and there's a risk that you don't find things, but you can do it yourself. There's also Design View, which you should be able to Google and find the URL for that. And that lets you look at other territories. You can also, though, ask the UK Intellectual Property Office to run a search for you. It's something that's really underused by both designers and lawyers. It only costs £24, so it is super cheap. And you basically show them what you're thinking of protecting, what your design is. They run a search and they flag up potential conflicts. Now, if either your searches or their searches identify potentially similar designs, then the test that you're looking for as to whether that's a problem, the test is whether an informed user, and that informed user is someone that's more design aware than the average consumer of that particular product, but isn't necessarily a technical expert. So I like to look at that as it's potentially someone working in the industry, maybe a salesperson in a showroom, not necessarily the person that's sat in the workshop coming up with it. It's that kind of level of knowledge within the industry. And it's whether that informed user sees the two designs as having the same overall look and feel. I mean, you couldn't get much woollier than that, could you? The overall look and feel. So it's not a particularly helpful test in terms of for kind of someone not experienced in the field to actually get an idea of what that means and what is conflicting. But the idea is that the two designs, or the design and the product, should be compared holistically. So it's not taking isolated features and seeing how similar they are. It's looking at them as a whole. As a result of that, even really small changes potentially could be enough for that informed user to form a different overall impression of the two designs and therefore avoid an issue. The threshold for what's different on that sense, so what's a different overall impression, doesn't necessarily require it to be a dramatic difference. It doesn't have to be really, really different. It's just enough to be distinct. Now, the more novel the design is, so if you've come up with a kind of product that no one's ever done before, then you almost get slightly wider protection, because someone can do something that aesthetically looks a little bit more different, but it could still be close enough. If you do something really run-of-the-mill, so it's like a ladder. If you do a ladder, but your ladder is slightly different because visually it looks different, you've got wavy rungs or something like that. I don't know, that sounds a really stupid idea now I say it. I feel like you're going to fall off it, but let's not worry about that for now. It's not a health and safety webinar. Then actually it's a bit closer. So therefore, small changes in that kind of product potentially move you further away. But if you're not confident in either running those searches yourselves or actually then evaluating the risk of things that you find, then you can get an IP lawyer to run the searches for you, or just show them the results and get them to advise on the likelihood of infringement risk. Whatever you do, keep records of the searches and the results of the searches, just in case a dispute does come up. If we're talking about things like copying, it could be quite useful to have that evidence. From a business kind of process perspective, I always advise clients to try and build those searches into their product development processes. So both running the searches, but also then keeping those records when the design team are coming up with things. So it's important that that's quite a formal step in your process before the product's actually launched. And then hopefully the step after that is to actually file the registrations yourselves, again, before the product's actually launched. So actually registering the design, so filing an application. So registering a design in the UK is really simple and unbelievably cost effective. I'm super keen on registered designs, as you can probably tell. I mentioned before, you apply online through the UK IPO. Theoretically, you can still file a paper form. It costs more though, it takes longer. I've never done it. I don't know why anyone would bother, to be honest. Just do it online. The fees for an application in the UK start at £50 for one design, but you can group multiple designs together and save money. So up to 10 designs, for example, £70. Up to 50 designs in one application is only £150. So £3 a design, absolute bargain. Those 10 or 50 or whatever number you get to designs, they could be completely different products if you wanted to. So in your 50, you could have your whole range of 50 products if that's what you've got. Or you could just do slight variations of the same or a number of different products covering slightly different things. When you file that application, what you need to submit are clear images of your design. Now, those images need to be on a neutral background because you don't want the background to have any impact on what's in the design. They need to be from different angles. So, front, back, top, bottom, side, everything. You need to add in a brief description. Keep it brief. It only narrows things down, so there's no point putting any real detail there. And as I mentioned, all designs are put into different classes. The classes don't affect the protection. They just affect where people can find it if they run searches. If you put a completely inappropriate class, the examiner will pick you up on it. So you can't kind of hide it. I'm going to put it in this so no one finds it. That won't work. But it's kind of from a drop-down list, so it's quite straightforward when you see it. The images can be photos, they could be line drawings, they could be CAD images, whatever shows the product, or more importantly, the design as clearly as possible. And that's because if you do get any infringement issues down the line, then the courts look at what's on the register, not what your product looks like. So it's important that those images are right. And that's the most important part of the process. Everything that's in the images forms part of the design. So if you've got a brand name or a logo on your images, then that's going to form part of the design. So if we think back to that Coca-Cola bottle that was on the first slide, if it's got Coca-Cola written on it, and that's one of the images that you submit for your design, then that forms part of that protection. So someone potentially could have a similar looking bottle without Coca-Cola on it, and they could argue that it doesn't look the same. It doesn't create the same overall impression. So my suggestion, take any logos off, because hopefully what you're looking to protect is, say, the shape or whatever else it is. So blank is actually better in that example. I advise filing a number of variations of the same design to ensure the broadest possible coverage. So that might well include photos of the product. It might also then be a separate design with line drawings. You might also have variations with different color or different shading to emphasize, can't even say it, different aspects of the product. The trunky case is a really useful one to look at. And in my notes, I've put that this was a few years ago, and that's actually showing my age, because I think it was probably 12 years ago, which is kind of quite depressing because it seems like it wasn't that long ago at all. Those of you with children will probably recognize these, or those of you that just happen to have been on holiday and been to an airport and seen a child being pulled around on one of these. So they are wheelie suitcases, animal kind of shaped. Normally you can attach like a clip with like a lanyard or whatever you want to call it, strap, that's the one, and so that the parents can pull the kid along through the airport. That's the idea. So in that case, Magmatic, which is the maker of Trunky, they had a registered design, and on the right hand side of that slide, you've got like the lineup, if you will. So the three images on the left, so the first ones are actually what Trunky had as a registered design. And the next two images, one of which is like a ladybird, the other one's like supposed to be like a tiger, they were the allegedly infringing products. So Magmatic had the registered design that you can see there. They accused PMS International of infringing it with their kiddie cases. The crucial legal question in that case was how the scope for registered design is determined. So how the scope of protection is determined. And specifically, when the registration shows certain features such as color, contrast, or surface pattern, like you get in a CAD drawing like that, then what does that cover? The court in that case actually, and disappointingly I think, ruled in favour of the defendant. So they ruled in favour of the people that effectively copied them, because they said that actually the design depicting in Magmatic's registration doesn't actually cover all aspects of what the product looked like. So in effect, what they were saying is, well, what was on the register didn't actually protect the product. So if they'd have done the images better, if they'd have followed my advice there of photos, line drawings, CAD, they might have had better protection. What the court found was that the registration was for a suitcase of a particular shape, and one that actually lacked any decoration or contrast because it's got nothing on there really to show that it's an animal. And what the court said is actually that was a deliberate decision not to include stuff like that. So not to include the decoration. And that in itself was taken to be effectively a feature. So the lack of features was a feature, which is a really confusing way that they phrased it, but that's what they said. Because the kiddie cases had different surface decoration, so as I mentioned, one is a ladybird, one is a tiger, that meant that they didn't infringe. So the case clarified that protection given by registered design is looked at fairly strictly in terms of what's on the register. If the representation on the register is ambiguous on one side, or if it's too specific on the other side, then actually knockoffs that do things in a slightly different way, make things look different, may get away without infringing. So what that emphasizes is it's really important that the images you submit are clear and precise, and also that they cover as wide a kind of gambit of options as possible. Subtle differences from the registered design, like surface, decoration, or color, can sometimes be enough to avoid infringement. So it's important to give real thought as to the images that you submit. Now, bearing in mind that decision, it's really wise to go nice and wide, nice and broad, lots of different variations, even if it's the same product. And as far as I'm concerned, the super low cost that I've mentioned basically means there's no excuse not to file everything, not to file every variation. Now, once you've filed that application, hopefully you follow my advice, you've got all these different images, you've covered everything possible. The examination process is limited, to say the least. It's pretty much a case if you fill the form in right, then it's going to get registered. Probably the main thing that causes problems or delays is when people don't send all the different angles. So I mentioned you should really have one of every angle of the product. And then you get knocked back from the examiner who says, please can you submit some better images? These don't pass the test. Otherwise, it's probably going to get registered what you file. And that's because the examiner doesn't do any searches. So this isn't like a patent where there's all these prior art searches. The examiner won't do anything. If everything looks okay on the form, they'll register it. So that's why it's really important that you run your own searches, but you also need to be aware that when it comes to enforcement, which Jill's going to talk about shortly, when it comes to enforcement, validity is going to be raised, or is very likely to be raised. So someone will say, oh, I'm sure I've seen this before. But the actual process usually takes a matter of weeks. But funnily enough, just before I jumped on this webinar, I had 2 certificates for design applications that we filed last Thursday. So they've taken a remarkable 7 days from filing through to registration. So super quick process. So we've talked about the differences between unregistered and registered designs. So this slide just summarizes the key features of UK registered design rights, UK unregistered design rights, and SUDs. We've talked about them, or I've talked about them. I'm not going to go through them again, but you get the slides at the end of the webinar, so you can kind of keep that to hand and peruse that at your will. The point I want to pick up now, though, is considering which one to go for or which combination to go for. So what you need to think about is how long you intend to manufacture and sell products to any particular design that you've come up with. For really short-lived or seasonal products, unregistered rights might be enough for you. fast fashion, for example, where you've got turnaround of styles within a matter of months or sometimes weeks. That industry will largely rely on suds. So because they get protection of the surface decoration, which obviously is important to them, and then it's only a 3-year duration. But frankly, if the product's only on the shelf for 3 months and then it's getting binned or whatever, then that's absolutely fine. But if your industry keeps products for longer, generally, or if they're products that you just know as a business you're going to be keeping for a slightly longer term, then registration is definitely worth the investment, the small investment. Also, you get those products where you think this isn't going to work, this isn't going to fly, but for whatever reason, or it's going to be really short-lived. But sometimes they can surprise you, and they actually become really popular, and you've got that 12-month grace period. So it's just kind of keeping things in mind. I've talked about the rights that a registered design gives you. Jill's going to come on to how you enforce those rights shortly. But I also just wanted to mention a couple of other benefits of registered design protection. One is that because your design is registered, it's on the design register. That means that competitors can find it. So if they're doing their DD about what other people in the industry are doing, what protection there is, should easily be able to find it. And hopefully that will deter them from getting too close to what you're doing. It might not put them off completely if they take advice. Maybe they won't take advice. They might think you've got the whole kind of product locked down completely. But hopefully it stops them getting too close to you. You can also publish the details, so you get a registration number. So you'll see people publish that on their website. And so again, that could be useful to deter people. Registered designs, they're an asset like any other IP. They're an asset of the business. If you've got them registered, that can make things easier on things like licensing, if that's an avenue you want to go down for the business. Also, if you look to either sell the assets or sell the business or otherwise seek investment, then having registered rights in place can make that process smoother. It can make the business more attractive for investors or buyers and just secure better value for you. So now I'll hand over to Jill, who's going to talk about enforcement of design rights.
Thanks, Ben. So you've protected your rights. Then what do you do in terms of if something goes wrong and you think there's someone out there infringing? Well, the first thing is thinking about how you find the infringements. So it's important to monitor the market and look out for any competing designs which may infringe your rights. If you think someone has copied your design, you need to act quickly. Start by gathering clear evidence, take screenshots, save listings. If you can, buy examples and note the important dates. So when you first spotted it, and if you can establish it, the date when that product was first launched. Then have a look at the rights you hold. Are you relying on registered design rights or unregistered rights? As Ben mentioned, they give you different options for enforceability, so you need to think about which one you're relying on. If you've got a registered right and the items are being promoted on a platform, for example on Amazon or Etsy, then you may be able to file a takedown notice through the platform, and that can be quite a cost-effective and quick method for getting it off the market. Alternatively, you might need to think about sending a cease and desist letter explaining your rights and asking the other party to stop selling or making if they're making it as well. In the event that doesn't prompt a response, you might then need to think about court proceedings. But before you do that, the pre-action protocols that are in place and govern court behaviour require that you send a formal letter of claim before you start the actual proceedings. And that letter of claim needs to set out the facts and rights that you're relying on and provide an opportunity to resolve matters. If you're sending cease and desist or letters of claim, then you need to avoid making unjustified threats. You need to make sure that you have a valid claim when you're referring to registered rights. And if you don't, if you're suggesting you have a right when in fact you don't, or that there's infringement when in fact there isn't, you might be at risk of a claim against you for making an unjustified threat of infringement. So it's always worth taking advice if you're going to take that step. It's also important to consider alternative dispute resolution. And the main method for that is mediation. And mediation can be a cost-effective alternative to pursuing proceedings to trial. It's encouraged by the courts and it can be undertaken at any point, both before and whilst proceedings are underway. And failing to consider mediation can have cost consequences if the matter goes to trial. A mediation is usually facilitated by a qualified mediator, and it takes place typically over half a day or a full day at a neutral venue. And the big benefit is that it provides you with a range of solutions which could include things the court can't award. For example, it could involve a new collaboration going forward or structured forms of payment. All sorts of imaginative things can come up in a mediation. From a practical point of view, you need to weigh up whether enforcement makes commercial sense. Is the copying enforcing your sales or damaging your reputation? Consider the risk of escalating disputes in terms of both time and expense. And sometimes a polite commercial approach can resolve matters quickly and preserve business relationships, particularly where there may have been unwitting infringement by a third party. If someone is importing counterfeit versions of your goods on a large scale, then you have the option of working with UK border control to stop them coming in at source. And similarly, trading standards are particularly keen to prevent trade in infringing items which are unsafe, and an early report to them can be a very cost-effective way of stopping infringers. Whatever option you decide to take, it's important to seek early advice from a legal advisor experienced in IP disputes who can really help you choose the right path. And remember that if you make an unjustified claim of infringement, you could potentially find yourself on the end of a counterclaim. So what does enforcement actually cover? Well, when we talk about the scope of design protection, it's not just about direct copying. It can also cover designs that create the same overall impression. So as Ben mentioned, even if someone makes a few tweaks, it could still infringe your design right. And using part of a protected design can also cause problems. But one key point to keep in mind is that with unregistered design rights, independent creation is not an infringement. So if someone comes up with a similar design on their own without copying, that's allowed so far as unregistered design right is concerned. In the UK, design rights can be enforced through the Intellectual Property and Enterprise Court, known as IPEC, which offers two routes, the small claims track and the multi-track. The small claims track, often referred to as SCT, is designed for straightforward cases, generally worth up to around £10,000. And it's informal, usually limited to a one-day hearing, and there isn't the opportunity to claim interim relief like injunctions before trial in the SCT. Legal costs aren't generally recoverable on that track, but you can reclaim court fees and some limited expenses. And it's typical for parties to represent themselves without lawyers being present if it's a small claims track matter. For the more complex or higher value disputes, there is the IPEC multi-track, and this allows for claims up to £500,000 in damages, and legal cost recovery is capped at £60,000 with a few limited exceptions. In the multi-track, you can apply for interim relief, so you can get injunctions, search orders, and orders for delivery up, and the proceedings are managed by a specialist judge using streamlined procedures which aim to keep the costs proportionate. If you've got a particularly high value, complex or multi-issue dispute, you have the option to bring that case in the High Court Chancery Division. And in that division, there are no limits on the damages or the costs recoverable, and the full range of interim relief is available. So depending on which court you choose, the remedies can include damages or an account of profits, an injunction or an order for delivery up or destruction of the infringing articles. And you may also be able to claim your costs back if successful. But design rights are only one of the intellectual property rights that may help you protect your design. You need to have a wider intellectual property strategy. It may be that copyright protection is available, especially if your design includes original artistic works like illustrations or graphics. Trademark registration might be relevant too if your design is part of your brand identity, and you get that with distinctive packaging, for example, bottles or logos. Passing off could be relevant as well, and this provides protection if you can show that you've built significant goodwill and reputation in your design and that someone else has sought to imitate it and cause confusion amongst consumers. Where you've got designs that have been created by an external designer, make sure your contracts clarify who owns the design so that you avoid any disputes down the road. And if your product has a novel technical feature, there may be an opportunity for a patent, although this is usually more complex and more costly, and quite frankly is deserving of a webinar on its own. When you share new designs with third parties prior to launch, always use a confidentiality or non-disclosure agreement to protect your interests during negotiations and development, and to prevent the third party from using your design without your approval. So in practical terms, it's smart to layer your protections, combining design rights with trademarks, copyrights, and contracts as appropriate. And finally, consider also whether you need to protect your designs internationally. Following Brexit, the UK rights no longer cover the EU. So if your business is operating abroad or sells online, registering key designs through the EU Intellectual Property Office or the Worldwide Intellectual Property Office, also known as WIPO, can give you wider coverage in additional jurisdictions and protect you in other markets and avoid costly disputes later. So to summarize, designs protect the visual appearance of products, which could be the shape, pattern, ornamentation, but not the function. Unregistered designs arise automatically, give you 15 years of protection. If it's a supplementary unregistered design, it's 3 years of protection, but they only prevent copying and not independent creation. With registered designs, you need to apply to the UK IPO, but the protection you get can last for up to 25 years and gives you stronger exclusive protection. It's easier to enforce, and it can be used even where there's been independent creation. Remember Ben's top tip, it's always a good idea to search for existing designs before you launch, and then look to protect your designs early using clear images and maintain good records of the creation process. Monitor for infringements, act quickly and seek advice, and be aware of making unjustified threats. And remember that for robust protection, look to combine your design right with other IP rights, so trademarks, copyright, non-disclosure agreements.
So that leaves me just to thank you all for attending. It's been great having you. As I say, if you've got any questions either about the webinar itself and the content, or just generally about designs, enforcement of designs, or other IP protection, then please do reach out and contact myself, Jill, or someone else in the team. Thank you.